Good afternoon. It's good to see all of you here. What could be better on a sunny Wednesday afternoon than coming to the state capitol to talk about the right to know law, right? I can tell by the looks on your faces that you've been anticipating this for weeks. Okay, well, good. My name is Craig Staudenmeier. I'm an attorney with Nauman Smith, Schisler & Hall here in Harrisburg. Here today with my colleague Joshua Bond, who's also an attorney in our office. I'm the chairman of the firm's Right to Know Media Practice Group. And you can tell by all these gray hairs, I've been working in this area for probably close to 25 or 30 years. I've seen the evolution of several versions of the right to know law. And so hopefully today, though, and I'm glad to see you here because one of the areas of the right to know law that I'll use the word is blossoming in the last year or so, and the new law has been around for 7 years now, is the impact it's beginning to have on private companies that contract with the government. So that's why we're here today, to see what you as representatives of your various companies that deal with government agencies at local or state levels, and how the right to know law may impact you both defensively and offensively. A couple of housekeeping matters before we get into the nitty-gritty. The presentation today is being videotaped, so if you have a question, and please, we encourage lots of questions because I think, I don't know about you, but how many seminars do you go to and you have certain things you want to get answered and you sit there for an hour and a half, and they don't answer one question that you had. So we want to try to make sure that we do that before you leave. So if you have a question, there are index cards that you can raise your hand or something, write your question on there and pass it out to the end, and Mary or someone else from DGS will pick it up and give it to us, and we'll read the question and answer it, hopefully, so that it picks up on the video. Also, I've been told to say if you have anything that chimes, buzzes, bings, or rings, you're supposed to silence that now. Okay? And one other sort of housekeeping matter, one of the advantages of being here today is that our firm has a blog that addresses right to know matters that we update fairly quickly, and you'll be entered onto that, so you'll be getting updates on right to know matters as they come up, and if you have a question that comes up, you certainly can contact Josh or I. We've developed sort of a quick one-page checklist that we have that we can review with you that will help you know sort of quickly where you are in a right to know situation if you encounter that. So with that said, I want to sort of launch into things. And now, the important thing about right to know law, when you hear about it, is you have to be in the right frame of mind. Okay? And, okay. Puppies. How do puppies make you feel? You feel good, right? And I want you to feel that way when you leave here today. I don't want to scare you about what contractors need to know about the right to know law. I do not want you to feel like this, like we did in the middle of winter, okay? We want to do the puppies. So when you leave here today, you're going to have some more knowledge about the right to know law and what you need to know and what you may need to do with it, and you're going to have a good fuzzy feeling about it, okay? I guarantee it. All right. All right, a couple basics. First of all, how many of you in your companies, or maybe in a former company you were with, had to deal with a right to know request? Okay. And was that from a state agency or from a local agency? Or both? State? Okay.
I've dealt with it as a state employee,
okay.
Government side, and as a consultant.
All right, so you were on the agency side and the contractor side. Okay, well, that's good. And as you can see, it's a good representative sample, but not most of you. And that's good, because I think it's important that you have some understanding of the right to know law, and hopefully when it occurs. And I believe as time goes on, the likelihood of that coming to be when you contract with a government agency is going to be more and more likely. And the ability of citizens, of the news media, of your competitors to reach information that you have to supply to the government is going to become more prevalent, and so that you can be prepared for it. There's a lot of misconceptions about the right to know law, but basically the right to know law boils down to this. Pennsylvania was one of the very first states to have an open records or right-to-know law. It goes back to the 50s when we first passed our law. And back then it was basically 2 or 3 paragraphs and covered about a page and a half. Now it's a lot longer than that. And it's gone through many revisions. But basically, the right-to-know law gives businesses, citizens, entities access to the records the government holds. All right? And there are defined terms under the Act that sort of limit that in certain ways or define how an agency has to respond when they get a right-to-know request. Let me say one thing right up front. Just because you contract with a government agency does not make you an agency, so someone can't go to you directly and give you a right-to-know request. It doesn't work that way. All right? So if you're Acme Inc. or, Mo, Larry, and Curly LLP, a requester can't come to you and plop down a right-to-know request and say, I want a copy of X. However, because you contract with a government agency and have to supply not just that contract, but perhaps certain information related to that contract, a requester may be able to reach that information, even though you're the sole possessor of it. All right? So, and basically, any legal resident of the United States can make a right-to-know request in Pennsylvania. There is some Supreme Court decisions that say, well, maybe it can only be a citizen of Pennsylvania, but so far Pennsylvania has not really pushed that issue. So as a contractor, what are your primary concerns? Now, Josh and I are going to talk a lot today about the defensive part of right-to-know from your perspective. But we're also going to talk a little bit about your ability to use the Act offensively. And what do I mean by that? I don't mean to offend anybody, but I mean you can use it to gain information from both the agencies that you either contract with or have a desire to contract with, or gain information about others in your line of work that might be competing against you. A lot of that information can and will be a public record, depending on how it's supplied and what it deals with. Now, let me move forward here. All right. We'll start off with the general premise, and then we'll work our way down. All right. Generally speaking, any record that a public agency holds, Commonwealth government, local government, any record they hold is basically presumed to be a public record. All right, so you start off with that assumption. And that was one of the major changes of the law in 2009. It created a presumption of openness. That was a 180-degree turn from what the law prior to that was, where you as a requester had to prove it was a public record. All right? So you go from that presumption. I see the sweat breaking out on your foreheads already, okay, especially the DGS people now. Really, I tell people, when you're talking about public records, it's like a hurdle race with 3 hurdles. Okay? 2 hurdles the requester has to get over, and the 3rd hurdle the agency has to get over. All right? So first of all, what's a record? How does the law define what a record is? Well, basically, a record is any type of a record, document, and we'll talk a little bit about it. It's emails, it's electronic records, maps, photos, drawings, that documents a transaction or activity of an agency. Crystal clear, right? Yeah, 100%, okay. And, it's an and, it's created, received, or retained as required by law or in connection with that activity of the agency. So it's a 2-part test, and the requester has to show it's a record. Now, in all honesty, that first test is not all that hard to get over. Right? That first hurdle is pretty low. Even I could jump over it. Okay? And just so you understand, something else, if you take nothing else away from today besides the puppy feeling, remember this. What form the record is in is irrelevant. It makes no difference if it's electronic, if it's printed, if it's a photo, if it's a map. It doesn't make any difference at all. An email, a text, no difference at all. It's what the substance of the record is that determines whether it's possibly could be disclosed under the Act. The second hurdle, okay, once it's determined to be a record, the question then becomes, is it a public record? That's the gold standard. That's what the requester wants, public records, and that's what the law requires to be disclosed. And how does it get to be a public record? Well, first of all, it has to be a record. Remember the first hurdle. And then the second public record's a little bit higher, is it in the possession of the agency? And in the law, there's no definites. It can either be actually in the physical possession of the agency, or the agency may have the right to what's called constructively possess it. All right, what's constructive possession? How many people here have a safety deposit box? Okay, all right. The stuff that's in your safety deposit box, do you have possession of it right now? Is it under your mattress or in your hand? Of course not. You don't have actual possession. But you do have constructive possession because you have a right to get that in your safety deposit box. That's basically the concept of constructive possession. And that's really, this concept of constructive possession is going to come into play more with contractors more often, in addition to the physical possession. So, okay, we're over the second hurdle. Now, third, this is where the agency comes in. Okay, it's a record. It's a public record, therefore it's presumed to have to be disclosed. Is it exempt or privileged? If it's exempt or privileged, even though it's a public record, it can't be disclosed. All right? And exemptions under 708B of the law, there's 30 enumerated exemptions. I like to tell people there's 30 plus 300 because there's a myriad of other exemptions there could be. Is it subject to a privilege like attorney-client? Or is there another federal or state statute or regulation or a court order, federal or state, that makes it private or makes it non-public? So if the requester gets over all those first two hurdles and the agency can't make an argument that it's exempt or privileged, it's a public record and must be disclosed. Now, there are exemptions. And Josh is going to talk next about some of the specific exemptions that may apply to you. But some of the more common ones, or some of the ones that I think would come up more often with regard to you all, deal with things like physical security that deal with buildings and public resources infrastructure, computer security issues, a lot of information dealing with computer privacy and computer maintenance is not public for obvious reasons. And then there are certain things, and I don't want to get too deeply in the weeds with you on this, but personal identification information dealing with things like employee numbers, phone numbers, email addresses, those types of things are also exempt under the Act by specific statute. So, and with that, I'm going to turn it over to Josh, who's going to talk a little bit more about ones that are more commonly come up with regard to contractor documents that deal with public agencies.
Good afternoon, everyone. I'm Josh Bond. Just so everyone knows, we can email you a copy of this PowerPoint so that you can review it later. The exemptions that I'm going to talk about, and remember, as Craig explained, anything that any record that the government has is presumed to be public. And so exemptions are reasons why the government does not have to release something that's in its possession. And probably the main exemptions that government contractors would assert to keep an agency from disclosing a record is either trade secrets or confidential proprietary information. And this is information generally that gives you a competitive advantage over your competitors and which you try to keep secret. So if you need to get a contract with a government agency, and in order to get that contract, you have to you have to submit a bid. You may have to submit information about your company to the government in order to win the contract that you don't want every one of your competitors to know about. And so what I'm going to explain to you is what information an agency does not have to give to a requester under the right to know law that you may submit whenever you are responding to a bid. First of all, there's a very narrow exemption for trade secrets. There's a uniform law called the Uniform Trade Secret Act, and that is a very defined term. Trade secrets are formulas, drawings, patterns, customer lists, technical information very specific information that your company, like for example, the formula for Coke is a trade secret that if for some reason Coke had to give its formula to a government agency, the government agency would not be required to then give that information out to the public because Coke's recipe is a trade secret. Now, as I said, trade secrets is very limited, so the right to know law recognizes that, and it actually gives a broader exemption for government contractors, and this is called confidential proprietary information. If you can show that the information that you are disclosing to the government would cause you competitive harm if it is disclosed to the public, then you have a basis for objecting to the agency disclosing that record to the public. So that's trade secrets and confidential proprietary information. There's some other specific exemptions that I'll bring up to you. There's an exemption for donor information. This frequently comes up with lobbyists and state universities and lists of donors to state universities. There's been a lot of litigation about that. Lists of donors are exempt from public disclosure, so they do not have to be released to the public. Any documents submitted in response to a bid or a request for proposal is exempt before the contract is awarded or before the bids are opened and all bids are rejected. So you can't find out what one of your competitors submitted in response to an RFP until the contract has been awarded. But once the contract has been awarded, everything that was submitted is potentially subject to public disclosure. There is a specific exemption that I point out. For example, if you have to submit financial information to demonstrate that you are economically capable of performing a contract, that information is exempt. The government will not disclose that. Now, you do have to let the government know if you have any objections so that they don't inadvertently disclose this material. And then there's also an exemption for social services recipients. So if anyone is involved in a business, a lot of times foster care or adoptions, that type of service is outsourced by the government. Anything that would identify the people that are receiving those services would be exempt from public disclosure. An important, those were the main exemptions. There's around, as Craig said, maybe 300 actual exemptions. We can't cover all of them here today. Moving on, the exemptions do not apply to what are called financial records. So if there is a record in the possession of the government that reflects how much money the government pays you or how much money you pay a subcontractor to do something, that record would be subject to public disclosure even if it was otherwise subject to some of these exemptions. So for example, if your confidential proprietary information is in your pricing information, that the government is going to have to disclose that. And financial records are defined under the law to very broadly any type of account, voucher, or contract dealing with receipt or disbursement of funds by an agency, but also any record dealing with an agency's use, disposal of services, supplies, materials, equipment, anything that's related to how much money the government is spending is most likely going to be subject to public access if a requester asks for it. And then one last thing with exemptions is that an agency has discretion to release records that are not public. So you may say to an agency, we we believe that this information is legally exempt from public disclosure and you shouldn't disclose it. The agency, under certain circumstances, has the discretion to say, well, we think it's in the public's interest to know this information even though it's exempt from public disclosure. So that's another thing that you have to watch out for when you're dealing with agencies. They most likely would notify you if they were going to disclose your information and give you an opportunity to object. That's
I'm going to go over here this time. Yeah. Okay, I see the worried look on your faces. Calm down. Take a deep breath. Okay? You're thinking, oh my God, Acme Inc.'s going to know what I'm doing, Okay, calm down. We're good. A couple things that, Josh was talking about the exemptions, and I always try to tell people, I have to tell you about my two favorite exemptions under the law, okay? And I don't think it'll impact any of you, but one is that no one can find out what library books or movies you took from the local library, okay? So I see you wiping your brow back there, okay, all right. And number two is you're not allowed to know the existence of any archaeological or ecologically sensitive areas, so you can't make a right to know request to find those out. So my comment always was that if someone really wanted to hide their records, they'd put them in an archaeological sensitive site, right? Okay. But no, there's a whole myriad of exemptions, and a lot of them will not apply to you. And some of them, and I just want to mention these very quickly, the agency itself will more than likely assert on its and your behalf things like what's called pre-decisional deliberation, things that go on beforehand in the agency, deliberating about what policy to adopt or who to hire or contract with. Those things, generally speaking, would be exempt as well. I want to talk now, though, about what I think will probably be the more common situation. Josh talked about some of the areas that will come up about these exemptions. How will that come up? One of the major shortfalls of the prior right to know law was that there was a big question about how one reaches records of private parties that deal with the government, okay? There was case law on it, but it was hit and miss, and the government, the courts came up with, an essential component of, et cetera. So when the new law was passed, Section 506D was written into the law. And basically, Section 506D talks about records in the possession of a third party. You all, except for those of you who are from the agency, okay? You all guys are the third parties. And the statute talks about how one specifically gains access to those records, all right? So, and there's really a three-part test the courts have carved out over the last couple years. And we tell you this not so you can become legal scholars on the issue, but so that you can go through your mind and understand how your contracts or documents that are related to your contracts might be publicly accessible. All right. Under 506D, basically to access the record of a third party like a contractor, you have to pass this three-part test. First of all, do you have a contract? Okay. Normally, I think it's safe to say when you have dealings with the government, normally you have a contract. Now, in some instances, I think in most instances it'll be written, maybe not always. For example, one of my partners is a municipal solicitor, all right? He doesn't have a written contract per se, but he has an adoption of his services and the rates he charges each year. Those are accessible as part of the contract, so to speak. A lot of you will actually have written contracts that you and the agency lawyers have toiled over for hours and hours to get together. I will tell you this right now, that generally speaking, that contract, pretty much all of it, is a public record, okay? But the mere fact that you have a contract isn't enough. There's a second part, and that is, in the contract, are you performing or assisting in the performance of a governmental function? Okay? Now, who here wants to know what a governmental function is? Me too. Well, the Supreme Court actually has a case that tells us. And the Supreme Court says that a governmental function is any function that's non-ancillary to the purposes of government. Okay, how many of you here understand that? Yeah, okay. Basically, and Judge Pellegrini in the Commonwealth Court, that case was his and then it was overturned, basically said anything the government does is a government function. And the Supreme Court said, well, wait a minute, not everything the government does, okay? And the example I give is, because somebody said, well, come up with what's an ancillary function of the government that wouldn't be a public record. Well, if you have a going away party for Joe who's retiring in DGS, you know, are you allowed to have those now? Maybe you're not, I'm not sure. That's not a governmental function, okay? And you probably couldn't find out how much they spent on Joe's sodas and stuff that they got for him. Other than that, just about anything else the government does is probably going to be accessible as a governmental function. It's going to be a tough road to hoe, a tough hill to climb, whatever cliche you prefer, to say, well, that's not a government function. Because the question is, well, why are they contracting with you if it's not a government function? You know? And then finally, the information sought, and this is the part that should give you some ease, is that the records sought have to directly relate to that contract and the performance of that function. So for example, if you contract with the government, it doesn't give a requester automatic access to all your computer records, all your documents, all your employee information. It does not. It has to fit, first of all, this three-part test. And what have the courts told us to sort of help us with that? Okay. With regard to third-party records under 506D, the constructive possession argument doesn't work, so to speak, because the court has said, well, those aren't records the agency's supposed to have and has a right to get. We're talking about records that are actually in you all's possession, okay? And for example, there was a recent Supreme Court case that dealt with Medicaid disbursements, and the court said, well, the money going from Health and Human Services, right? Okay, I'm old enough, I keep calling it DPW. It's Health and Human Services. That goes to this first level of contractor that like Aetna and those that disperse it out. That's accessible. The next level down to sort of a middleman that would hire actual providers, it goes down that far. But once it gets below that level, it's no longer considered to be accessible because it doesn't directly flow from the governmental payments that are being made. So you have a little more protection here. If you have a contract with the government, the requester is going to get that contract, and they're also going to get any document that directly relates to that contract in some manner. Governmental function, we talked a little bit about this already. Now, one thing I did want to tell you all, because especially for those of you who deal with the government, you may have encountered over the years what I call the municipal law test of governmental proprietary function, okay? There's this thing about there were certain contracts that new boards could reject if they were governmental or proprietary. That test is meaningless and right to know. Just put that out of your head when you're looking at what I mean by a governmental function, okay? Just to give you some examples, some sort of examples over the years that have been held to be records like this that are accessible through 506D. For example, payroll records of a contractor who was performing maintenance on a university building. The contractor had a contract with the university to do this work. Someone wanted to, I think, do a prevailing wage check, and they wanted the payroll records of the employees. Those were accessible because the employees were actually working on this contract, and their information, minus their social security numbers, any other personal identification information, you would know the name and how much that person was being paid. Bids that were made and this is one of my favorites. This is actually the very first Supreme Court decision under the new law. The Yankees have is it the Red Barons in Scranton? Yeah, thank you. And they took over the stadium, and when they did, magically, a company that was controlled by the New York Yankees got all the concession contracts. Now, how'd that happen? But someone made a right-to-know request. They resisted it, and the court said, no, that deals directly relating with the operation of this stadium, and therefore is a record. It's accessible, and is operating a baseball stadium a governmental function? And the court said, well, it's a close one, but the government does it. They floated bonds to do it. The government built and ran the stadium initially, so they said, yeah, it's a governmental function. And some of the others that you can see here, management records of operating a charter school, training notes about how people calibrate speed timing devices, okay? What things, this direct relationship, we talked about what's the court determined does not meet that direct relationship test. I'm sorry. Well, and these are some other information, but where's my favorite one though about the, yeah, this is my favorite one down here. It has nothing to do with the fact that it was with DGS, all right? But there was an agency that provided translator services, and the requester wanted every employee or independent contractor that worked for that service, even if they had not actually provided services under the contract. And the court said, no, if you never provided any services under the contract, that doesn't directly relate to the contract. It's only those people who actually provided services. And it's sort of a fine distinction, but one that makes logical sense because those people never benefited from the public money. And people, that's the purpose of the right to know law. The purpose of the right to know law is to track the collection of and the expenditure of public money. So if you're a contractor with the government and you're being paid with public money, the law says that some of your records should be accessible by the public so they can track how it's being spent and to sort of do the sort of citizen's job of overseeing and making sure government is operating properly. And as I said, I think I mentioned before, the independent who hadn't performed, things like contractors that were providing these certain foster care services were not providing the placement services directly related to the contract that the agency had, and therefore the court held they were not directly related. I honestly wish I could stand up here and draw you all these black lines and say is, isn't. But the law is new. I mean, believe it or not, a 7-year-old law is a baby in Pennsylvania. And when the law was first passed, I told everybody it's going to be 10 years till we have a solid body of case law. And we're in our 7th, going on our 8th year. We're getting there, but there's still a lot of gray area. But I think just knowing some of these general parameters hopefully will help you know sort of at least what questions to ask should it come up as to this question about direct relationship. But like I said, keep in mind that the contract you have, most of the information in that, and any documents relating to that about employees that work on that contract and what they're paid, as long as it ties directly to the expenditure of public funds, is more than likely going to be accessible under the right to know law. Now, there are exceptions, but that's generally what's going to happen. Okay, now we're going to go to the question of, okay, now that we've panicked you thoroughly, how do I go about protecting some of that information? And not just, we're not talking about nefariously protecting it. It's what does the law give you the right to protect? Because let's face it, there's information that should not be public. It should not be public for a variety of reasons with regard to people in your classification. You have the right to protect certain business information, certain proprietary information, because you have to be able to compete in the market, and compete fairly. So Josh is going to talk about what the law allows, or the steps the law gives you, or the abilities it gives you to help protect some of the information from being accessed by the public.
Okay, and just to review what Craig had been talking about, remember that the government has to give out records that are in the government's possession, and the government can also order someone who has a contract with the government to give those records to the government to then disclose to the public. And so what I'm going to talk about now is how do you prevent the government from either giving information that it already has about you, how do you prevent the government from giving that information to the public, or how do you prevent the government from coming to you and saying, you have this information that's related to this contract and someone in Maryland wants this information, they filed a right to know request, so you have to give it to us so we can give it to the person in Maryland. How can you prevent that from happening? And that's what I'm going to talk about. The first step that you must do if you don't want the government to give out your information is you have to tell them what information you do not want them to give out. If you respond to an RFP and you submit a 400-page proposal, the attorney for the government, their first priority is not going to be to go through that contract and try to figure out everything that the contractor may not want be disclosed to the public. Make that job easy for the person who's reviewing the contract for the Commonwealth. Tell them if there's information that you're giving to the government, tell them why it should not be disclosed to the public. And I'm going to go over a form that DGS has, but one of the main instructions I would have for you is don't submit a 400-page proposal and say, this is all confidential. If you say that, the government attorney is going to assume that nothing is confidential because there's just no way that all 400 pages would be confidential. So you need to pick the important information that you really don't want to be disclosed. You need to identify it, and you need to tell the government why they should not disclose the information. There's really 3 gatekeepers to access in Pennsylvania. The first gatekeeper is the agency. The agency is going to make an initial determination whether they are going to disclose your information to a citizen that makes a request under the right to know law. So the agency makes the initial determination. If the person who wants the information doesn't agree with the agency, they can appeal. There's a state agency called the Office of Open Records that decides whether the agency correctly denied access to public records. And then there's also an appeal to the courts. And so it's your job, if you want to protect your information, to convince all 3 of those gatekeepers, the agency, the Office of Open Records, and the courts, that this information is not subject to disclosure under the right to know law. This provides a great guide. This is a form. I'm sorry if you can't see it. We'll send it out in an email. It's called the Trade Secret Confidential Proprietary Information Notice. This is on the DGS website, and this is something that you would submit whenever you submit a response to a request for a proposal or a bid. You would fill out this form to notify the agency of the information that you do not want to be disclosed to the public. There's a couple of things about this form I want to point out to you. First of all, it says right on this form, the Commonwealth will not give you legal advice about whether your information will be disclosed or not. So if you want to protect information, you can't call the government and ask them for an opinion about, well, if I give you this information, would it be disclosed? The government is not going to give you that information. You're going to have to seek that information from your own counsel or from reviewing the law. What you have to do whenever you fill out this form, you have to tell them who you are. You have to explain the information that you are submitting, and you have to provide a explanation why the information shouldn't be disclosed. And there's a log. And basically what this is if you have a 400-page proposal, you have to notify by page. Pages 55 and 56 have the Coke formula. That's a trade secret. It should not be disclosed. And you have to go through your whole document and notify the agency whenever you're responding to the RFP of the information that you do not want to be disclosed. Now there's a catch. This is the legal acknowledgement that you have to sign whenever you fill out this form. And here's the catch. If you don't want the government to disclose your information and the government is going to get into a legal battle with a concerned citizen that wants the information, the government asks you up front, if you want to challenge the disclosure of this information, you have to indemnify the government. You have to agree to pay the government's legal costs. So the government is not necessarily, sometimes the government will independently try to protect information if it's clearly not a public record. But at other times, if it's some kind of technical information, like a trade secret that the government doesn't really know whether or not it's really exempt, that is something that you are going to have to protect on your own, provide your own legal counsel, or Fortunately, with the Office of Open Records, you don't necessarily need legal counsel in Office of Open Records proceedings. They do accept submissions from non-attorneys at the first level. And then the last thing about this acknowledgement is the government reserves the right to disagree with you. They reserve the right to release your information even if you don't want them to. And if the government says, we are going to release this information, then you have to pursue your own remedies in court or in the Office of Open Records to prevent the government from doing that. About whenever, this is the initial gatekeeping step. An agency will receive requests for public records from members of the public. And the agency has almost no time to review and respond to this request. They get, if a citizen goes to the Department of General Services and says, I want every single contract with telephone companies that the Department of General Services has, Department of General Services has 5 business days to respond to that request. That's not very much time. They can request a 30-day extension, and they usually will, but even 30 days, I mean, we can be talking about a massive amount of material that the agency has to review and decide whether or not to disclose to the public. And you can help the agency out if the agency receives a request for something that you have told them is exempt from public disclosure, they will notify you. We have received the right to know request. We have requested a 30-day extension to respond to this request. The response is due by X date. Please give us any argument or evidence that you have to help us respond to this request. And then the agency will make an initial determination whether or not it's going to disclose the information. And in our experience, the agency will usually err on the side of the business rather than on the side of the requester, meaning if you tell the agency that the information is exempt, more often than not, the agency is not going to release that information. They probably are going to deny the request for information and let you litigate that issue in the Office of Open Records or in the courts. So if you get notified by an agency, Department of General Services notifies you, we've received the right to know request. It appears to request information that's related to this contract and this work that you perform for the agency. Are there any reasons that you're objecting to disclosure? You have 5 business days under the right to know law to respond. And that's not the agency trying to give you a hard time. That's the amount of time that's given by law for the agency to receive a response from the contractor. The agency may give you more time if you ask for it, but remember the agency only has 30 business days to respond to the right to know request. So they're not going to be able to give you much of an extension of that 5 business days. And what I'd really recommend at this initial stage is that you give at least a preliminary, if you receive a notice that the agency's received the right to know request for your information, give the agency a summarized version of why the record shouldn't be disclosed. And then you can bolster that with additional information at a later time. So that is how you notify an agency of whether or not you want information to be disclosed.
Okay, how everybody feel right so far? Good? Good? It's like 10 to 3, you're hanging in there. Okay, 50 minutes down, 40 to go. Okay, everybody still with us? All right, good. A couple of general comments too about the right to know law. I think another important thing for you to understand is, I call it the funnel. All right, when the legislature passed the new right to know law, one of the other fundamental changes that was made besides the presumption of openness and the creation of the Office of Open Records was that the legislature and the judiciary came under the right to know law for the first time in our history. Okay? Now imagine that. The legislature wasn't under it before. Anyway, but this is where the funnel comes in. And basically, with regard to the executive agencies, the executive branch, the most records are available from that branch. They're the top of the funnel. The legislature saw fit to basically say, well, you get our records, but only in about 17 or 18 enumerated categories. And they're actually listed in the law, different things that are subject to disclosure. And then the very, very bottom of the funnel is the judiciary. And basically, the only type of record that a person can get from the judiciary under the right to know law are financial records. Payrolls, expenditures, budget expenditures, costs for buildings, employees, those kind of things. So sort of understand, and I tell you that so you can sort of orient yourselves. You know, if you're dealing primarily with the executive branch, okay, more often than not, that's going to be the widest possibility of available records. The legislature, not quite as much. And if you deal with the judiciary, God help you, okay, you're here, down at the bottom part of the funnel, okay? Another thing that I think is important for you to realize is, and I always ask people this because they're always surprised. If you had to give me a guess as to who you think the largest single, or in other words, what person or entity or type of business or do you think makes the most right to know requests? Go. No. The media makes about 14 to 15% of right to know requests. Well, see, they don't break them out that way, but probably they fall in all the categories. But they make a lot, but not the largest part. Right now, it's prisoners. Okay? I don't know how many of you have deal with, yeah. But once you take the prisoners out of it, it's individual citizens. And then the media. And guess what section's been growing over the last 3 or 4 years? Business entities. Okay? Because you all are starting to learn that not only are you subject to this thing, but it's a way for you to access information too. And the media, like I said, varies between 14 and 20%. And the other thing I like to mention is about 4% of requests are filed by public officials. And I had a case a couple years ago where a woman was the minority commissioner at a township in Perry County, and because she was the minority commissioner, they wouldn't let her see the books. And she had to make a right to know request to see the check ledger. Okay. But I think it's good for you to see that, to understand those requests. And we're going to talk a little bit now about the Office of Open Records. And if you'll indulge me for just a few more minutes, I want to tell you a little bit about the Open Records Office. First of all, has anyone here been involved in an appeal to the Open Records Office? Okay, good. Okay. It never existed before January 1, 2009. That was what I called the third major change in the law, was the creation of the OOR, the Office of Open Records. In fact, you may have been aware last year there was even a fight over who the executive director was going to be. That's been settled now. Okay, Mr. Arneson is in place again and running the office very well now that Terry Mutchler left. But I want you to understand a little bit about the Office of Open Records, because I think, you know, I can say, well, if you take an appeal to the OOR, but you have to understand what you're dealing with. Last year, the Open Records Office had a record number of appeals filed to it, almost 3,000. Okay, 3,000 appeals. Most of those, well, they were split fairly evenly, state agencies, local agencies. But the Open Records Office has, I'd say, 7 to 8 appeals officers, the people that actually hear and judge the appeals. So do the math. Okay? Basically, each appeals officer handles, what's that come to? About 300 appeals or something like that, okay? And a variety of, some can be dismissed right away, some require 15-page decisions, you know. So, and on top of that, they're doing training, they're promulgating regulations, they're answering questions on the phone. So you understand they're under a lot of pressure, let's say. And Josh will talk in a few minutes about dealing with the court system. But the courts, the Commonwealth Court has said that, and just to, if you'll let me do some legalese here for a minute, the Open Records Office is an administrative agency. If you take an appeal from the OOR, it either goes to a common pleas court if you're dealing with a local agency, or with a state agency, it goes to the Commonwealth Court. When it gets to the court can hear it as if nothing happened before. You know, that's the Glinda thing. Be gone. You have no power here. Okay. But the Commonwealth Court has said smartly, if you're going to take your shot, you better take your best shot in the Office of Open Records, because we don't like the idea of having hearings, you know, and taking evidence. All right. I tell you that to sort of lead into what Josh just got done telling you. If you believe information of yours is about to be disclosed that you do not want disclosed, you better make a good shot in the Office of Open Records. Don't blow it off and say, well, you know, I don't have to deal with them. And when it doesn't happen, I'll take an appeal and we'll get to the court and we'll do it there. Well, you may or may not, because I can tell you, I've handled quite a few of these in the Common Pleas Court, and the Common Pleas Courts aren't all that thrilled about having evidentiary hearings and taking evidence and devoting time to this. In fact, Josh had a case not too long ago in Philadelphia County. The judge there had never even heard of the right to know law. Okay? All right. Now, I'm not talking about the current one. I'm talking about any right to know law. Okay. So, you know, if you have an appeal to the Open Records Office, you know, you better take your stand there. You may get another crack, but you might not. Okay. So, like I said, the Open Records Office is if a requester makes a request to an agency, and I won't bog you down, it depends, you know, but basically if they make a request to a Commonwealth agency or to a local agency, and by that I mean city, borough, township, county, and any municipal authority, that's going to go to the Open Records Office. There are some exceptions, but basically most of them go there. And the Open Records Office has 30 calendar days to make a decision once the appeal's filed. All right, so remember I told you about 300 appeals each, 30 days to make the decision? Okay, they're a little rushed. Now that can be extended, but only by the requester. The agency can't extend it, and if you're involved, you can't extend it. Only the requester can agree to extend that time under the current law. There's legislation pending that would change that, but right now, only the requester. So I'm just trying to give you the scenario of where you're going to be in the Office of Open Records. So you got to make sure that you marshal your assets quickly, that you get your information as to why you believe, and you have the burden. If you believe the information is proprietary or you believe it's protected under some other exemption, you have the burden to show the Open Records Appeals Officer that you meet that burden and it should be exempt in some manner. The requester does not have that burden. You do. And as you've seen, the agencies, you know, I meant to ask you, how many of you deal primarily with the Commonwealth agencies? How about local agencies? Okay. The local agencies aren't as, I'm going to use the word sophisticated, but by that I mean the DGS, for example, these forms came up early on and were an excellent idea about how to help you demonstrate what should be proprietary. A lot of local agencies don't have that. So when you contract with them, if you have information you believe is confidential, proprietary, or otherwise exempt, our suggestion always is that when you file the documents or you respond to the RFP, you segregate that information. In other words, don't mix it all through the thing, but segregate it and mark it. We believe this is confidential, proprietary under 708B, you know, I can't remember what it is now, the numbers. You know, and mark it so that the local agency itself doesn't have to pile through 300 pages of submittal to see what you think is exempt and what you think isn't. All right? So, like I said, and we tell you that because when you get to the OOR, and you don't have a lot of time. When the appeal is filed, the OOR will send a form letter that'll tell you, we've received your appeal, and it goes to everybody. It goes to the agency and to the requester. It'll say, you have 7 business days to submit any additional information you want to submit in response to this appeal. And if you believe there's a third party who should have input into this, you need to notify them and send them this form and tell them that they have a right to participate, a direct interest party. But you didn't know you were a direct interest party. No, I didn't say DIP. I said direct interest party before you came here, okay? And if you get this form, which you probably will if it's the agency is information that might be exempt, you'll get this form, and you have to fill it out and say, we think it's exempt, this is who we are, this is why we think it's exempt. And notice the little check boxes, you know, these records deal with, I'm an employee, it contains confidential or trademark information, I'm a contractor. You have to check those boxes and send it in to the OOR, and please don't just fill out that form, okay? Because if you just fill out that form, you're probably not going to prevail. You better send with it some explanation based upon the law as to why that information is confidential, proprietary, as to why it's subject to attorney-client privilege, or whatever other exemption you believe fits your protection as a contractor. And you can't count on, the agency will assert a lot of those, but you can't count on them solely. And because you are a third party who has an interest, you have a right to participate in the appeal. And in fact, the current law probably gives you the right to take an appeal to the court if you can prove some kind of proprietary interest, some due process violation. And, excuse me, if you have information that's a trade secret or something that, you know, that's definitely proprietary, you probably can assert that interest and directly participate in the appeal. So if you get one of these forms, don't throw it away or just check the box and send it in. Send along with it some type of an affidavit from someone with knowledge of what's going on, whether that's the CEO or whether it's the chief marketing person or the person in your finance department, excuse me, that knows what the basis of this information is and why it's exempt. And remember what we talked about earlier, that it's going to cause you competitive harm, or that it's actually protected as a trade secret, or there's some other basis upon which to block it as confidential or proprietary. Excuse me, I'm on the downside of a cold. So you can file a written request to participate if the agency doesn't notify you, but of course that means you have to find out about it. All right, but take heart, if it does get appealed to the court, you probably could seek to intervene then as well. You have 15 days of receipt of that notice, and you can't jump in once the OOR has made its decision. Although if 30 days or more have gone by, it's probably too late anyway. And you don't need legal counsel, but you know, I'll leave that up to you as to whether you think it's a good idea to venture into these waters without it. One of the biggest things, you know, the open records law was changed with the thought that it would make it easier for citizens to gain access to records and not have to hire lawyers. Unfortunately, that hasn't come to pass. Understand that if you appeal or you intercede and seek to block the information, if the agency believes it needs to be released and intends to release it, you're going to have to take some other action to block that release. Now, you're going to say, okay, Craig, we traveled all these miles today. It's 3:02. What do we do? Well, that's a good question. And one of the reasons that's a good question is because one of the things the open records law is horrible at is procedure. There's hardly any specific procedure available. But my recommendation would be if that's going to occur, and I think that would be rare, but if it's going to occur and you feel confident or you feel strongly about the fact of protecting this information, you know, I'd first appeal to the Open Records Office to stop that, or go to court and get an injunction to stop it while the decision is pending. Obviously, that's going to take time. You'd have to move for a preliminary injunction. That's going to be expensive. It's going to happen quickly. But really, the law provides no other remedy. And you know, you can ask the agency to provide a written statement that they'll hold on to it until you have a chance to fight it. But it depends on the agency and how they feel about it. And they have no obligation to give you that either, particularly if they feel the record should be released. So this is the open records environment that you're in. Understand, like I said, about you have this appeals officer who's handling 300 appeals or more, because at times there's only 6 appeals officers, and they're also filing briefs in the Commonwealth Court. So you're going to have to make it concise, make it quickly, and make it to the point so that when that person looks at it, they can analyze it quickly and decide whether whether they're going to go with you or not. Don't give them a 20-page treatise. It's not going to work. And whatever you do, whatever you give them, make sure it's in the form of verified testimony, whether by an affidavit, all right, because they tend not, even though they're not required to have affidavits, our strong suggestion is that you make it in the form of an affidavit. They're more likely to give it weight if you do that. All right. So once you get past the OOR, if there's an appeal to the court, that's where Josh is going to talk about the legal challenges there. I'm going to go cough in the corner, excuse me.
And before we dive into everyone's favorite topic about how court procedures work, do we have any questions? If you do, as we said at the beginning, we prefer if you put it onto a note card so that we can read it for the video purposes. And while Craig's reviewing those, so I told you there's 3 gatekeepers. There's the agency. I talked about the agency. There's the Office of Open Records. Craig just told you about proceedings in the Office of Open Records. The 3rd gatekeeper is the courts. And so this is if the Office of Open Records may have told an agency you have to release these records, or the Office of Open Records may have said to the agency you do not have to release these records. Regardless of what the Office of Open Records does, whoever didn't win in the Office of Open Records can appeal to a court to get a final decision about whether something is a public record or not. And this final part is about the proceedings if that happens. So the first thing that would happen is either the agency or the requester disagrees with the determination of the Office of Open Records, so they file an appeal with a court. Either the Court of Common Pleas in the county where a local agency is located, or if it's a state agency, in the Commonwealth Court. What rights do you as a third-party contractor have to participate in those proceedings? And this has been answered just this year by, either this year or last year, by the Commonwealth Court, that third parties have the right to participate fully as a party in court proceedings. For the first 6 years of the law, that was not clear, and actually I argued unsuccessfully on behalf of a requester that there was not a right to participate as a full party. And the Commonwealth Court said, no, government contractors can participate as full parties. And that's very important to you, because if the agency is not cooperating with you as a third party, this is really your only shot to prevent the information from being disclosed to the public. Most of the time, the agency will be in agreement with you and will be by your side trying to keep this information from being disclosed. But if they're not, you do have an opportunity to participate as a full party. Talking about, basically the point of this slide is once you get to the courts, the procedures at that point are so complicated, and you have to be represented by legal counsel if you are in a court. So you are going to have to retain an attorney at this point if it gets to a court and you still want to fight the disclosure of information. So really that's the point of the remainder of my portion of the presentation, is that if you get this far, you're really going to need to talk to a lawyer about particular advice. Government contractors also have a right, if an agency will not pursue an appeal, to pursue their own appeal from an adverse decision of the Office of Open Records. Are you ready to do questions, Craig? Or do you want to? I can answer some too if you want to.
Yeah, here, why don't you? I'll take some of these and provide them all.
And before we do this, I also want to let you know, I'm going to email everyone here a copy of the PowerPoint as soon as I get back to the office. I have also prepared a one-page checklist that you can use as kind of a cheat sheet. If you want the one-page checklist, I'm not going to email that out to everyone. I'd ask that you either send me an email or that you call me, and I will be happy to send that checklist to you. And if you want, I'd be happy to explain it to you over the phone. Questions?
See, I knew you'd have good questions. All right. I'm going to take this one first because these are some good sort of fundamental questions that I think are important to understand. First part of the question is, does the person making the request have to give the reason why they want the information? No. In fact, the agency cannot ask what the reason is. And the reason is irrelevant with regard to whether the request should be granted or not. Now, I can tell you, and we'll weave this in, there's legislation pending right now, Senate Bill 411, that would make major revisions to the right to know law. So hey, 7 years, we're just starting to get our feet on the ground, and guess what? You know. But one of the changes that would change this, and something you need to have on your radar screens, and you may want to talk to your legislators about this, is that if you're making a request for a commercial purpose, you have to state that it's for a commercial purpose. And guess what? They get to charge you labor fees then for searching for the records. Okay? Educational, scientific, or news media organizations would be exempt from that. But that's the proposal, that they would be able to charge you a labor charge, which they cannot currently charge, for searching for and responding to records. All right? But if you would have to fill out an affidavit. It says, I'm a commercial requester. I'm going to use this for a commercial purpose. Now, you don't have to say exactly what the commercial purpose is. And does anybody here sell pool chemicals? Okay, because it's the pool chemical people getting all the agencies all upset because they're filing right to know requests every week, and they want to know who has a building permit for a pool so they can send them, you know, hey, we have the best pool chemicals and those noodle things to sell. Okay? All right. That and the dog grooming people. Got everybody had a dog license and sent them information. So it says, can we see who is requesting the information? Yes, a right to know request is a public record. Okay? So if someone makes a right to know request, you have the right to know who that is. In fact, you have a right to see the actual request. It's a public record. You can go to the agency and say, hey, I want to see this record request that was made. In fact, some agencies publish them or publish a list of all the requests made every year. It just depends.
You can make an anonymous request, but the agency does not have to, technically the agency has to respond to it, but if an anonymous request is made, the person who made it anonymously has no way to enforce their request unless they put it in writing.
Yeah, you don't get the protections of the act, but you can, which I always thought was kind of, okay. Anyway, and the last part of it is there a statute of limitations on how far back the requester can go? No. But the courts have basically said if you start asking for information over, you know, a broad period of time, it may start to become insufficiently specific or, you know, burdensome in a way that might get the agency out of answering, but it's going to have to be something like you want something over the last 100 years or something. I mean, but there is no time limit. And someone can say, for example, I want all of the contracts between Acme Inc. and the Department of Revenue from 2000 to 2015 or from 1990. That's, even though it covers a large span, it's very specific. One entity, one agency, one entity, so that of itself is going to be okay. That's probably not going to be a reason to deny the request.
I can take one. I have a question. The Pennsylvania Department of Transportation's bids for townships, can they not tell the bidders who won the bid and the results? How do you obtain this information? Okay, if I understand this question, this would be the township that is awarding the bid. And the township would not be able to award the bid outside of a public meeting. Under the Sunshine Act, a local agency cannot conduct business. It cannot make official decisions outside of a public meeting. And how would you get that information? A lot of local agencies publish their minutes for their meetings online. And so the first thing I would do is try to just get the information online. A lot of times the information is stale. A lot of local municipalities are 3-4 months behind on putting their minutes online. So if it's not up to date, you can file a right to know request. I would also, before you file a right to know request, I would call the business office at the township and ask, hey, can you send me a copy of the minutes for X meeting? You don't have to tell them what you're looking for. They'll probably give it to you without requiring you to file a right to know request.
I have a comment on this too. I think it's important to note, and you can correct me if I'm wrong, but especially with dealing with townships and whatnot, people can ask. It doesn't hurt to ask first before filing an official right to know.
Yes.
Because all that does is that puts an additional burden on folks. When you could have just asked for the information, you might get, because ultimately people are going to know who asks anyhow.
Yes, and that's, for the sake of the video, the courts have actually held that you don't have to file a right to know request to get public information. You can just go and ask for it, and the agency can give it to you. And if it's something that's not controversial, like the minutes of last month's Board of Supervisors meeting, the agency's probably going to give that information to you without you having to file a right to know request. If you file a right to know request, then there's going to be a delay in the response. So you should try to work these things out, as the person in the audience said. I have a question. Exemptions under Section 708 regarding trade secrets, patents, intellectual property seem in conflict with bid language. Can you address? Answers can you send from? And can you send?
Actually, kind of answered that. There's a follow-on to that question, and that's the time frame. If you already have an award, and you have a patent issuing during the award, can you send a form in after the fact to help the agency with that?
Yes, and you should. The best practice would be to notify the agency as soon as the issue arises, rather than waiting until there's a right to know request, because one of your competitors in that industry may try to get the information through a right to know request, and you really want to let the agency know that that's going to be an issue.
Yeah, and that's a very good point, because too, don't forget, I assume a lot of the contracts you have cover multiple years and extend for some period of time. Make sure, as part of whatever normal review process that you do, that you make a review. Is there any other updated information or additional information, or have the courts held that some other information that I didn't exempt is, or that I exempted isn't, and let the agency know. Because here again, I told you about the appeals officers. Well, think of all the agencies you deal with, whether it's the Commonwealth, whether it's the local agencies. They're being asked to do more with less, just as you are too, but they're being asked to do it all the time. And so the easier you make it for them to delineate what you think is exempt, the more likely you are to be successful, at least in that initial phase when the request comes in.
Another question here. Are any strategic plans within agencies subject to the right to know law? And I'd answer that, favorite answer as an attorney, maybe. Remember, it's presumed to be public. However, there may be an exemption, a strategic plan. Has it been published before? Is it something that contains pre-decisional deliberative information? You may be able to get part of the strategic plan, and other parts of it are redacted because they're pre-decisional. That's really I can't really give a general answer to that question without having more specific information. I have another question. I talked about with bids and if a contractor has to submit proof of financial responsibility. And the question is the financial info demonstrating economic capability only exempt prior to award or after award too? That's an exception, so no, the financial information The financial capability of the person who's awarded the contract would always be exempt from public disclosure under the right to know law.
Okay, and I have a couple others too. These are good questions. Good for you guys. All right. It says, what information about the people included in the proposal or contract is an open record? So what is it you don't want to tell people? No. Generally speaking, remember what I talked about being directly related? For example, we gave you the example, if you have the roofing contractor that had a contract with the university to fix the roof, the information about the name of the employee, the salary or hourly rate paid, you may be able to access background or resume information. Well, I shouldn't say resumes, but qualification information if it's vital to the contract. In other words, if the contract provides that you're going to provide tutoring services and that the tutor will have at least a BA or BS and have degrees in elementary ed or something, you probably could inquire to get that information. However, this would never be public information. What that employee's home address is, what that employee's personal cell phone number is, their social security number, their employer ID, driver's license, any of that information would never be public because not only is it exempt under the right to know law, but some of that information is exempt under a whole myriad of federal, state regulations and laws as well. So that information would not be. But some of the what I call qualification and payment information. Remember, they're going after the money. The money's, and if the requester can link his request to money, boy, you have an uphill fight because that's why you have an open records law, basically, to track money. And then the other question here was, can the requester ask that the records be delivered in a specific format? The law requires that if the information exists in a format, the requester can demand that it be delivered in that format. So, for example, if you have it in an Excel spreadsheet, you must provide, and he asks for it, or she asks for it, you must provide it in that form. You can't say, I'm going to PDF it, or no, you have to provide it. And some people say, well, how do I know they're not going to take that information and swoosh it all around and change it and then go on their blog, IHateGovernment.com, and tell people that that I'm getting all this money from the government and I'm working hard for that? Well, my lawyer answer to that question in the first place is, you can't stop them from it. But don't forget, you've got the original. But you have to provide it in that format if it exists in that format. And if all you have it is electronically and the requester wants it in paper, you have to give it to them in paper. But you get to charge them 25 cents a sheet. Okay? So there you go. So $7.25 is worth the trouble, right? Yeah, although, let me tell you what I've seen. As we progress and the years go by, more and more requesters actually want it in electronic format. They're getting away from paper for a variety of reasons. Now, not to get too deep in the weeds, but one thing that we didn't touch on, I just want to touch on quickly is, I don't want you to also think in absolutes. Okay? In other words, oh my God, if this record is subject to the right to know law, the whole thing is going to be released. No. All right? Parts of it can be exempted. Parts of it can be redacted. In other words, you may have a whole page, and let's say 2 parts of it have information that is confidential, proprietary, or it's got the employee number or their social security number. The agency has to redact that and produce the record. They can't withhold the whole page, and they can't produce the whole page. They can redact. In fact, the law requires the redaction. And the same thing with what we've talked about in terms of segregating your information or filling out the form that the DGS suggests. That information can be plucked or redacted, and then the document's turned over. But in terms of, to answer the question, yes, if he wants it in an electronic format of some sort and you have it in that format, you must produce it. If you do not keep it in that format, you do not have to produce it in that format. You can produce it in the format that you choose or the easiest for you to produce. And one other thing I want to tell you, and it's just sort of another thing, the courts have said, let's say a requester makes a request for something that requires the agency to pluck information from certain parts of its database. That's not creating a record. Okay, the courts have said that's no different in the old days. We used to have to go to the filing cabinet, open the drawer, pull this piece out of here, close the drawer, get onto this drawer, open it up. That's the same thing, only electronic form. So the fact that that the agency may keep it in a database and that they may take 15 fields and the requester only wants 8, you have to give them that 8. That's not creation of a record, all right? You may hear that thrown about. I just want you to, I don't think it would as much directly affect you all, but you might hear that in the fury of the fight, so to speak, so you'll understand what's going on. One other thing, there are some other places that we always recommend people go to. The Pennsylvania Freedom of Information Coalition provides a lot of information on right-to-know requests for the general public, including the Open Records Office has a great website, except don't try to search their decisions because it's really, really hard. But they provide a lot of guidance, a lot of answers to questions. They provide forms. They cannot provide legal advice. I don't know where you go for that. And also, the Commonwealth agencies, have an agency open records officer guidebook, which might give you some understanding as to how the open records office, officers work, at least the Commonwealth part. And then, like I said, we maintain a blog now. My younger people in our firm say it's not really a blog, Craig, because people aren't allowed to comment. But we try to update you on the current state of the law, legislative changes, proposed changes, things that have come up. And like I said, you'll be getting these automatically since you attended the seminar today. They'll give you sort of updates as they come, and they basically talk about a lot of the cases that come up, the recent cases, Supreme Court cases, et cetera. And we give you a sort of a handle to look at it there. And of course, if you get to that point and you have a question and you want to contact us, Josh and I would be happy to talk to you about any situations you might run into. And there's our contact information again. Are there any other questions that anybody has with regard to? Yes?
I don't think this has changed, but if somebody's asking for something that's outside the window of the agency's record retention policy, and the
Good
agency
point.
has truly followed their own policy and got rid of that record, then you don't have to provide it. Is that sound correct?
Yeah, this is a very good question, and since we were compressed into 90 minutes, we didn't get into Josh and I do what I call our records retention spiel. In fact, next week in front of the Township Association, we're going to be doing this. The right-to-know law does provide that if the agency has a record retention policy, and I know the Commonwealth agencies all have one. The local agencies, it's hit or miss sometimes, okay? But if you have a record retention policy and you have disposed of the record in compliance with that policy, you're clean. I always tell agencies, because especially local agencies, will say, how many of you have a record retention policy? 30% of them will raise their hand. And I say, okay, how many of you follow it? I represent a lot of requesters, okay? And I always tell them, well, think of me standing there saying, Judge, this township has a record retention policy. It says they dispose of these records, after 5 years. And, and my guy asked for stuff that's only 4 years old, and yet they say they threw it away under their policy. And the judge says, yeah, what about that, Mr. Smith? Why did that happen? It's better not to have a policy if you're not going to follow it. So, but we in fact, that's the next wave of open records, from the agency standpoint. And also, to some extent, for you all, but I suspect that you all are much better at maintaining your records, at least I hope you are, because the Commonwealth will deal with, you times 1,000 kind of thing. But if the agency has a policy, if they follow it, they're golden, because that's a defense, if you will. Hey, we can't give it to you 5 years ago because we disposed of this after 3 years. But if you have it and you don't follow it, you're in trouble. And if you don't have any and you're throwing stuff away willy-nilly, what's the first thing I'm going to say? Well, I made this request. I think they threw it away because I made the request. So you want to avoid that. But yeah, and in fact, I would encourage all of you that contract with the various agencies that you check out the agency you're dealing with, what their record retention policy is, so that you know for your protection as well, or so you know what you may have to do to beef up that protection of your information. Anything else?
Craig, I wanted to add,
Yeah, sure, go ahead.
to follow up on one of the questions I was asked about actually making a right-to-know request. Every single agency, local or state, that has a website is required by the right-to-know law to post their right-to-know policy on their website, and they're required to accept the standard form that's promulgated by the Office of Open Records. It's a one-page form for requesting public records. So just to give you the nuts and bolts answer, if you want to make a right-to-know request, go to the website of the agency that you want to get the records from, and there should be more information there.
Well, on behalf of Josh and myself, thank you all very much for your attendance and for sitting through a 90-minute thing on the right-to-know law. If you have any questions, we'd be happy to answer them. Also, please, there's still stuff left over there. If you don't drink it, I will. So, you know, and I don't need that sugary Coke to drink. So thank you again. Have a safe journey home.
Thank you.